Okay, well, let's get started, such as it is. And again, I apologize for the bad picture, but I am here, and I know you all are anxious to go. So, all right, so let me call the case. This is 20CV480 David Piniella versus Old World Creamery LLC et al. Who do I have for the plaintiff?
Laura Callan of Stafford Rosenbaum for the plaintiff, Your Honor.
Okay, how about Old World Creamery, Stephen, is it Knass, and OWC Waterfront?
Attorney Sherry Coley of Davis and Kielthal, Your Honor. Okay,
thank you. All right, who do I have for Next Level Dairy Products and Joseph Ballestieri? Daniel Teagues and Lance Linz, or Daryl Teagues?
Good afternoon, Your Honor. Aaron Ninneman of Gerber's Law. There's one other Next Level entity that is on the bottom of the caption that you didn't mention, but I'm here for 2 Next Level entities and 3 individuals.
Okay. And the law firm, William Everson and Everson and Gibbs?
Good afternoon, Your Honor. Daniel Feinberg on behalf of the Everson defendants from Gordon Reese.
Okay, so we're here on a bunch, several motions for partial dismissal. And I've spent a fair amount of time on this over the course of the last few weeks. So I'm up to speed on the briefs, the responses, the replies, and I may have some questions. I know that there's several motions, so we'll take them one motion at a time. I know there was a combined response, and there are some general issues that I think we need to address right up front that may make this a little bit easier. It seems to me that one of the crucial issues, at least with the 3 individual defendants, Ballestieri, Teagues, Linz, and then also with Mr. Knass, is this issue of are they individual defendants acting as their individual capacity, or are they or the allegations such that they were only acting in their capacity as a member of the various LLCs? Does everybody agree with me that that is one of the principal issues relating to the 4 individual members?
Yes, Judge, and Daniel Feinberg for the Everson defendants. I would just add that that issue also is applicable to Mr. Everson and his law firm. Okay, thank you. Attorney Coley?
Yes, Judge. I think you've identified a key issue for all the individual defendants.
Okay. Attorney Ninneman?
Yes, Your Honor, you are correct. That is one of the main issues. I think certainly the largest with respect to the individuals.
Okay. Attorney Callan?
Yes, I would agree with that characterization of the issues.
All right. So let me start with that because I think that deals with some of the motions. All right. So here's what I have gleaned from the various pleadings and responses in the law. Let's see if I can summarize it. Under the statute, and let me get you the exact language of this. At least I thought I printed it off. But that's all right, I have it up. All right, what I'm looking at is Wisconsin Statute 183.0304, liability of members to third parties. And it says, the debts, obligations, and liabilities of a limited liability company, whether arising in contract, tort, or otherwise, shall be solely the debts, obligations, and liabilities of the limited liability company, except as provided, and then has a couple other sections I don't think that are applicable. A member or manager of a limited liability company is not personally liable for any debt, obligation, or liability of the limited liability company, comma, except that a member or manager may become personally liable by his or her acts or conduct other than as a member or manager. And then the second paragraph says, notwithstanding sub 1, nothing in this chapter shall preclude a court from ignoring the limited liability company entity under principles of common law of the state that are similar to those applicable to business corporations and shareholders in this state, and under circumstances that are not inconsistent with the purpose of this chapter. I don't know about you, but that seems to be about as clear as mud to this court. However, and unfortunately, there's not been a lot of case law on this. Really, the only published case is this Bruce City Redevelopment versus Furchchill Group. It's a 297 with second 606 Supreme Court case that the Supreme Court decided in 2006. Is everybody agreeable to what the court has just said regarding the relevant statute and the Bruce City case? Anybody disagree that that's sort of the guiding principles on this issue?
Your Honor, Aaron Ninneman for the next level defendants. As far as the individual liability goes under 183, I think Your Honor has fleshed out the issues. I think, and perhaps the court is going to get to this, but I think a corollary issue is just the fashion in which some of these things are pleaded. But I'll let the court finish in this regard.
Okay, thank you. Anybody else want to chime in before I continue?
I do, Your Honor. This is Laura Callan. I would also direct the court's attention to section 183.1302 sub 2, which provides that unless displaced by particular provisions of this chapter, the principles of law and equity supplement this chapter. The plaintiff reads that to mean that Chapter 183 does not displace the black letter law that a person is liable for his own intentional torts. So I would just direct the court to that additional provision in Chapter 183.
And what was that section again, Attorney?
It's section 183.1302 sub 2.
I'm sorry, one more time. 183 what?
183.1302 subparagraph 2.
$183.10 what?
I'm sorry, 183.1302 sub 2.
Okay, thank you. Okay, thank you. I think, okay. And again, then the cases under that section talk about Marks versus Morris, which is another relatively new case, a 2019 case on LLCs. Primarily that case dealt with the ability of one member to sue a member of a different LLC and the common law breach of duty, of fiduciary duty, and just enrichment, and were they preempted. But I don't think that anybody would disagree that if there was, similar to other corporate law or employment law, there is this concept of vicarious liability, or the liability of an agent is binding on the principal. If the agent commits a tort, the agent, it's him or herself, could be liable. And if acting within the scope of an agency relationship, the company could also be liable, or the principal. What I'm thinking at is the common example of if a doctor commits malpractice while working for a clinic or a hospital, the doctor themselves is personally liable, and so could be their employer. And as far as this court can tell from reading the Brew City case, it's sort of the same concept. In that case, the court said, well, based on these allegations, there might be some individual liability because they alleged that in the complaint that they alleged that the individuals acted individually and not as a manager or member of an LLC, and so that it was conduct other than a member or manager. And therefore, the court, and I'm looking at page 626, says that the individuals may still be liable for tortious interference with contract if they conducted such interference other than as members or managers of Juno. And that Brew City's third cause of action alleged that they were acting individually. And so court, based on that, provided or found that they couldn't decide and couldn't grant a motion to dismiss on the individual members at this stage of the pleadings, because the allegations had to be taken as true. But in this case, if you look at the allegations in the pleading, it said that Brew City alleged that Franco boasted in front of Milwaukee's mayor that we're going to have Hartel so tied up in covenants and restrictions that will control his buildings as well. They verbally berated him. They directed profanities towards him, told him he was in over his head and that he would blankety blank fail. They asked at several meetings if he'd suffered enough and said that he hadn't suffered enough. They belittled and disparaged his abilities. And they all concern harms to Brew City's reputation and business. So there was a pretty explicit allegations in the complaint that said what these individuals allegedly said and did that would constitute individual actions. And in my mind, and perhaps I'm wrong because this is not an area of law that's been fully fleshed out, a LLC would have an expectation that its members or its managers would not commit torts, would not act in a way that would cause a tort. And so as an employee acting outside the scope of their employment, a member that goes off half-cocked and does certain things may have some individual liability for his actions or her actions. If it's simply a contract dispute and there is a question on interpretation of a contract or something, then that would not be sufficient to cause an individual action against the member, because the statute specifically provides that that members of an LLC are not liable in contract or tort unless as an individual. So similar to a corporation, if you make a mistake and you breach a contract or whatever, the corporation's responsible, but not the person who breached the contract. However, if the individual intentionally does something, that they would be individually liable. So that's kind of a long way to get to the complaint. And I looked at the amended complaint to see what were the actual allegations. We all know that Data Key says Wisconsin requires more than just legal conclusions. We also know that Wisconsin is a notice pleading statute or state, and Data Key allegedly did not change that in any regard. But having said that, I have reviewed this complaint, or the second amended complaint, over and over, and for the most part, the only allegations are that these individuals, Teagues, Ballesteri, and Linz, are a natural person, and they are personally liable even though they may be acted as an agent. But in this complaint, I find nowheres in the allegations, and there's a significant number of allegations. There's 181 individual allegations, and there is no allegations as to what these three individuals supposedly said or did. I don't think you can just lump them together with the LLC and say, these LLC individuals and LLC, collectively the LLC defendants, acted poorly or did something, and therefore they're all liable, including the people individually. I don't think that that's what Bruce City says. I think Bruce City says you've got to have specific allegations as to these three individuals that will, in fact, tell the court what they supposedly did individually. And then you say, and they took these actions individually with not on behalf of their LLC. And that might be sufficient, but there's nothing in here that says anything other than they were members of the LLC. And if that was the only thing that was needed, then you're not going to have any situation in which a LLC member wouldn't have personal liability. I think it's insufficient. I don't think that you can, I don't think that's enough in the complaint, even taking all reasonable inferences in favor of the plaintiff, which I must at this stage. So I don't think there's anything that shows that Ballesteri, Teagues, or Linz did anything individual. Kraus, or Knass, that's a different story. Mr. Knass, there is one allegation that he emailed either the plaintiff's counsel and said, and I'm trying to find the specific paragraph. Does anybody know what that is?
It's paragraph 72, Your Honor.
Yes. He represented that he had dismantled and removed the equipment collateral from the premises. He stated, I did talk to my attorney this afternoon, and he advised me that I needed to be upfront with you that the equipment is removed from the building. I hired a company, and they removed it. I needed the space. He advised me that I should not keep it secret anymore, that the company is removed. It's at their yard. Some of it's sitting outside my building yet, which are they going to be picking up. if that was false, and again, at this stage, there's an allegation that that was false. There's an allegation that the plaintiff relied on it to his detriment. That, to me, would be the sufficient individual actions that would be sufficient to be alleged to be had made individually instead of a member of the limited liability company, if it was a fraudulent misrepresentation that may bind him and or the LLC. So on that basis, at this stage of the game, I am going to I'm going to deny the motion for partial dismissal against that specific individual. I think under Bruce City, the court is required, in taking all reasonable inferences, to find that this was, in fact, something that could have been an individual action taken outside the ordinary duties as a LLC member or manager. All right, so that's as to that. And now we're talking about OWC Waterfront LLC, and this is directed to Attorney Callan. What allegations show that they had anything to do with this and or that there is a cause of action against them?
Give me a minute, Your Honor, please.
Okay, and I know this is a little unorthodox the way I'm doing this. It's just in sorting through all these motions, I tried to come up with what made sense to the court if I was trying to narrow down the issues.
Your Honor, this is Attorney Coley. May I ask a question to clarify your decision regarding Mr. Knaus? The complaint, and I understand your ruling to be regarding paragraph 72 and the claim for intentional misrepresentation. The motion seeks to dismiss him from all of the claims. So my question to you on clarification is, what does the court feel? Is he still, I guess, a party defendant regarding all of the claims in the complaint, or was your ruling for the intentional misrepresentation claim?
Well, I think it's to the extent, because all reasonable inferences have to be in favor of the plaintiff. He's still a party to the causes of action. I mean, I think they all relate back to his role in supposedly misleading where the collateral was and what happened to the collateral. And that's consistent with what Bruce City allowed, and I don't know if that was specified in any of the briefs, but it seems to me that there are a number of causes of action, but in essence, all this relates to the collateral. And the misrepresentation that was made was part of the assertion that his LLC did not have the collateral. I don't know if it makes much difference, but it seems to me that he would still be in on the declaratory judgment, the conversion, the civil theft, the intentional misrepresentation, civil conspiracy. That's a different, that one, nobody's filed a motion to dismiss on that one, at least on that basis, and the replevin. So I would say he's still in. Granted, Bruce City doesn't give me a whole lot of guidance with this, but I think the allegations as to what he did in an individual manner may give him some liability on some of these other causes of action.
Your Honor,
Okay.
Attorney Callan, bringing you back to the allegation against OWC Waterfront. It is at paragraph 166. And the allegation is that Old World or OWC Waterfront accepted payment for the plaintiff's property, even though it had no connection with or legal right to that property. So the contention here is that OWC Waterford unlawfully retained the proceeds of the sale of the plaintiff's property. And that receipt of stolen property or the proceeds thereof gives rise to a claim for conversion and civil theft and conspiracy, and makes that LLC a part of the scheme here.
OW Waterfront accepted payment for plaintiff's property. Were they the initial company that was, or did they get it through? Where did OWC Waterfront, who did they purchase the property from?
The check that was written to OWC Waterfront. So they accepted payment in the sense that the check was made payable to them.
From whom?
From Mr. Linz.
If I may, Your Honor.
You may.
Thank you, Aaron Ninneman. That the notion that it came from Mr. Linz is not set forth in the Second Amendment complaint. I think it's maybe part of the record for the purposes of a different motion, but I just want to make that clarification. Thank you.
How did OWC Waterfront have the property in the first place?
I'm not sure, Your Honor. The only facts that we know is that OWC Waterfront, which is alleged to be an affiliate of Old World Creamery and owned by Mr. Knaus, received a check representing the purchase price of the plaintiff's property.
Your Honor, if I may, there are no factual allegations in the second amended complaint that say OWC Waterfront LLC is an affiliate of Old World Creamery, or that it is owned by Mr. Knaus, or that it owned the property. That's part of what is present in our motion to dismiss. That there is an allegation in paragraph 6 that states that OWC Waterfront is a Wisconsin LLC. There's an allegation in paragraph 30 that states that OWC Waterfront is a domestic limited liability company. And then there is the allegation in paragraph 166, which relates to OWC Waterfront. But aside, those are it. Aside from that, it would go to what Mr. Ninneman referred to earlier as far as OWC Waterfront is grouped into a group pleading style regarding the OWC defendants.
To be clear, Your Honor, OWC Waterfront is alleged to have the same registered office as Old World Creamery. You can look at paragraphs 2 and paragraph 6 to confirm those allegations.
what I'm struggling with it is we're lumping a bunch of people and entities together, and there's no So what we have is a related, the fact that they have the same registered agents is neither here nor there. There's quite a few companies that may have the same registered agents, related entities, but assuming that they are related, the allegation is that OWC Waterfront accepted payment for plaintiff's property even though it had no connection with it or legal right to that property. That's an allegation that they were paid for the plaintiff's property even though they had no basis for it. And so then the question is OWC Waterfront a proper party to all of these causes of action? I will deal with the first cause of action is declaratory judgment. That if they accepted payment for a property that wasn't it, okay, OW Waterfront, that seems to be an appropriate cause of action. Conversion, that's against the Old World Creamery defendants, which OWC Waterfront is one, or at least grouped together. That I think is sufficient because it's saying they got paid for my property. The third is civil theft against the Old World Creamery. Again, that's arising out of its, deprivation of the property. The next causes of actions are against other people. Misrepresentation against the Old World Creamery defendants. We'll talk about that later. Seventh cause of action against the Old World Creamery defendants. There's nothing that ties Old World Creamery Waterfront with that intentional misrepresentation, at least at this date and juncture. The trouble here is we have causes of action relating to a dispute over who owned this property and what did what, and we have a number of defendants that may or may not have been part of it, and we have a number of causes of actions that may or may not ultimately make sense. And frankly, we have the burning question is, does this equipment and really work? And are we spending a lot of time and are the lawyers spending a lot of money fighting over something that may not even work? But that's neither here nor there. I'm trying to sort through what's in and what's out. I'm going to All right, let me think about that.
Your Honor, if just to direct your attention to paragraph 152 of the complaints, alleges that Mr. Knaus's misrepresentation is imputed to Old World Creamery. That's meant to be the Old World Creamery defendants.
But even so, how can his misrepresent be imputed to OWC Waterfront when we don't even know where OWC Waterfront was in all of this?
Well, OWC Waterfront is alleged to have received the proceeds from the sale. We can reasonably infer that they are that OWC is related to Old World Creamery, and that whether Knaus was acting as an agent for one or both of those LLCs when he made this representation is something that will be the subject of discovery.
If I may, Your Honor, this boils down to what's being alleged. There are no allegations that Mr. Knaus owns OWC Waterfront. There are no allegations that OWC Waterfront is an affiliate or alter ego or anything of the sort from Old World Creamery. There are no allegations that OWC Waterfront has an interest in the equipment, nor has the plaintiff sought turnover of funds as a cause of action in the second amended complaint. The mere fact that OWC Waterfront received a payment, which is the only factual allegation, the allegation pled in paragraph 152 saying that Mr. Knaus's statements can be imputed on the LLC isn't necessarily a factual allegation. That's a legal conclusion, which you are not obligated to take as true for purposes of the motion to dismiss. So Mr. Paolella has come to this court saying he wants his equipment back, has brought claims relating to the equipment, not turnover of a check paid to OWC Waterfront. So the allegations in the complaint must somehow tie OWC Waterfront to the equipment and to these claims that Mr. Paolella has been denied access to that equipment.
Attorney Callan?
The proceeds from the sale of this equipment belonged to Mr. Paolella. And when OWC Waterfront retains that property that belongs to Mr. Paolella, that is a conversion. And that's what we've alleged, Your Honor.
But you haven't, oh great, my battery died. Sorry, it appears my laptop died, but I could still see you. I'm sorry, I don't, hang on, let me go plug it in.
You can still see you, Your Honor.
Oh, okay, I don't know why I can't see anybody. Huh.
Additionally, Your Honor, again, to be clear, we are seeking money damages.
I understand, but my concern is, all right, well, my concern is, how can you get the money that you say OWI Waterfront had, and yet at the same time seek the property back? I mean, I could see it in the alternative, but you can't get both, it seems to me.
Well, and right now, Your Honor, the second amended complaint does not seek both. The second amended complaint seeks turnover of the equipment. And for purposes of this motion, you must look at the factual allegations in that second amended complaint and whether there are sufficient factual allegations that would make OWC Waterfront a proper party to that. And it would be our contention there are not. And again, you've already parsed through there are parties or causes of action that are going to survive today. So to make this a little more streamlined based upon what the plaintiff has alleged so far under the second amended complaint does not completely deny the plaintiff an avenue or source of recovery.
All right, well, I do agree that if I look at the causes of action that are in the complaint, it is against the first one, declaratory judgment, says possession, custody, control of the collateral. Second claim, they're seeking an order enjoining them from using the collateral and returning it to the plaintiff. The third is seeking damages from the deprivation of the property. The fourth is conversion, seeking the loss from the use of the property, further use. Civil theft is again relating to the property. That's the fifth cause of action. Sixth cause of action is for damages relating from the misrepresentations. And again, there's nothing that ties OWC Waterfront to the alleged misrepresentation. Allegations that he is acting as an agent without any factual basis is insufficient. That's the seventh cause of action. Again, there's no real factual allegations regarding the civil conspiracy. It talks about the property and the permanent injunction and the replevin. Again, there is nothing regarding the payment. That's the 10th. The ninth cause of action is tortious interference. So the only one that it potentially might be was that civil conspiracy claim. Took his property. So other than, I'm going to dismiss OWI Waterfront from everything other than maybe the eighth cause of action, civil conspiracy, because a reasonable inference is if OWC received payment from that property, they were part of the scheme to deprive the property. So OWC Waterfront's out other than the eighth cause of action. All right, so then as to the lawyers, I think the law is pretty clear on this, that there has to be a basis for lawyers in general are not, do not have a duty to a third party unless, but obviously they have a duty to a third party not to commit fraud. And I think everybody agrees to that. Let me pull up that. All right, the immunity of an attorney who acting in a professional capacity is qualified rather than absolute. That is true. That's a Stride versus Converse case. The immunity applies unless an attorney acts in a malicious, fraudulent, or tortious manner which frustrates the administration of justice or to obtain something for the client which the client is not jointly entitled. So here, the only allegations against the attorney and or the law firm was this one statement made by the attorney that said, and this is at 69, in connection with a request to remove the equipment, the plaintiff's counsel informed Everson, who was acting as Old World Creamery's counsel, of the strict foreclosure and asked to schedule the removal of the equipment collateral. That same day, Everson responded with a statement. I apologize for the delay. A couple weeks ago, I was informed by Steve Knass that I was no longer going to be handling this matter for him. He was going to handle it himself. All right. So then the plaintiff alleged this was false because he was representing the Old World Creamery defendants and trying to sell the equipment. And then on the 13th, 2 days later, the defendant, Steve Knass, represented to the plaintiff that he did talk to his attorney, and then he advised me that I had to be upfront with you that I sold the equipment. So I've already ruled that Knass may have been acting individually when he made that statement, and he's still in. However, I cannot, even with all reasonable inferences in favor of the plaintiff, the only allegation against the attorney, and of course then his law firm, is the statement that I apologize for the delay. I was informed by Steve Knass that he was no longer going to be handling this matter for him, which was in reference to the removal of the equipment collateral, which is evidenced by 2 days later, the defendant in fact responded and told him about the equipment, making this alleged or likely misrepresentation. So even with all reasonable inferences, I still cannot conclude that the lawyer or the lawyer's law firm acted in a malicious, fraudulent, or tortious manner, partly because the statement he made, with all reasonable inferences, was saying, I'm not handling the removal issue, my client is. Now, maybe the statement Mr. Knass made saying, I talked to my attorney, maybe that wasn't true. Maybe that was fraudulent. Maybe through further discovery, you find out that the attorney knew the equipment was still there and was directing him to make a fraudulent statement. That's down the road. But for now, based on this record and all reasonable inferences on the motion to dismiss, I don't think there's anything here to tie in the counsel and his qualified immunity and his law firm. Maybe this was a grand scheme that they knew that the UCC was clear and that they didn't have a leg to stand on. I don't know. That's for a later battle, probably on a in-camera review, but I don't see any fraudulent scheme on behalf of the attorney. As I indicated before, this is a UCC question where, frankly, is not cut and dry. I've ruled before on the temporary injunction that I believe the plaintiff does have a substantial likelihood of success, but that doesn't turn what the defendant's counsel was advising into a fraud, nor does a statement saying, my client's going to handle this, make it a fraudulent statement when the client, in fact, did then respond to the plaintiff. So I'm dismissing the attorney and the attorney's law firm from this.
Your Honor, Daniel Feinberg for the Everson defendants. Just for point of clarification, you're dismissing them in their entirety, correct?
Correct. This is all triggered on that statement, and that's the only statement that's in front of the court now. So, all right. So then the last thing is there was a motion to dismiss the tortious interference of contract claim. And I guess my question, Attorney Cowan, is how can the allegation that GE, I think it was GE, or maybe it was
General Mills.
General Mills, sorry. How is it that General Mills might have been interested in this property when it was in the hands of defendant, give rise to a tortious interference with a potential contract with your client when there's no allegation that your client knew about General Mills or had any discussions with them about this property?
Well, Your Honor, the gist of the claim is this, that while the Old World Creamery defendants were converting plaintiff's collateral and ignoring his turnover demands and ignoring their knowledge of his duly perfected security interest, they were attempting to sell this collateral to General Mills on the representation that plaintiff did not have an interest in this collateral. The business opportunity to sell the collateral to GM or any other third party belonged to plaintiff and not to the defendants. So, you know, it's just, it's a conspiracy that, and to misappropriate a prospective contractual relationship. So that is the gist of the claim. And if the defendants want to defend the claim on the basis that they didn't know about General Mills, and these are the next level defendants, they can do so, but the claim is plausible, and that's the standard under data key, and the plaintiff should be allowed to prove its case at trial.
But under Wisconsin law, a claim for tortious interference with a contract requires proof of 5 elements. The plaintiff had a contract or a potential contractual relationship with a third party. 2, the defendant interfered with that relationship. 3, the interference was intentional. 4, there's a causal connection between the interference and damages. And 5, the defendant was not justified or privileged to interfere. Here, the plaintiff has not alleged that it had a potential contractual relationship with General Mills. All it's saying is there might have been one, and if I had known about it and had been able to work on it, I might have had one. But this was not something that the plaintiff had. And in every claim of a potential tortious interference that I've ever seen, it's the plaintiff's relationships that were being interfered with. Here, in essence, it was the defendant had a relationship, and General Mills was like, yeah, no, we're not going to take you up on it because we think there might be somebody else who might have a claim to this collateral. So, in essence, General Mills was shying away from entering into any relationship with the defendant as a result of the plaintiff's potential claim. Can you point to me any case that says it's sufficient if the defendant had a relationship and the plaintiff says, well, if I had known about it, I might have had that relationship?
Well, I think we're relying on the language of, there's no Wisconsin case that addresses this, except perhaps in the context of a tort for interference with economic opportunity. I think the name of it is. It's another branch of the restatement of torts. So I understand the court's position, but I have to believe that there's a tort here, and that there is a remedy for the plaintiff when defendants misappropriate or attempt to misappropriate a prospective contractual relationship under circumstances where they had no right to.
Okay, any response by any of the defendants?
This is Attorney Coley, Your Honor. I think your emphasis is exactly where our motions went, that in all times when a plaintiff is alleging tortious interference with a contract, The allegations rest on what contract did the plaintiff have, or what prospective contract did the plaintiff have that was interfered with by the defendants. And is simply no allegations in the second amended complaint that establish those basic facts.
All right, I'm dismissing the tortious interference cause of action. I mean, really what we have here is a collateral. We have a dispute regarding collateral. Who had the right to the collateral? Who should get the collateral? What it's worth? Were there any damages as a result of the delay in the plaintiff receiving the collateral? Assuming that the court got it right regarding what the UCC and the who had the rights in the collateral when, all of which are factual things that will be, I'm sure, fleshed out for the court down the road. So I'm dismissing the individual defendants other than Mr. Knaus. I'm dismissing OWI, Waterfront, except for the conspiracy allegation, or the civil conspiracy allegation, because all the other causes of action relate to the actual collateral, not the proceeds. I'm dismissing the attorneys and their law firm on the grounds that the statement that was made doesn't prove, it was, even with all reasonable inferences, is not a misrepresentation that would submit a fraud claim against the attorney or his law firm. And I'm dismissing the tortious interference with contract claim against the defendants. Now, having said all that, we're early on in this case. I know somebody has asked the court to not allow any further amendments, but as you all know, as justice requires that leave to amend should be freely granted. If after discovery is undertaken, there is a basis for some of the allegations against the people individually and or the law firm, assuming that there's any factual basis that would support it, we will take up a motion to amend at that time, and the court will decide what it's going to do. I'm not going to dismiss this with prejudice because this was filed. Yeah, we're with, I think, still, it was filed in September. We're within the 6 months, and frankly, with COVID, we're not going to try this case for a period of time. So we'll set this for further scheduling in a couple months. Again, I do want to just revisit this issue that the court raised. You all are good lawyers. You know what you're doing. But, you know, I've spent 25 years doing collateral disputes, starting with a Chevy Chevette that didn't run to a negotiable or a vessel, a boat so big that you have to sue the boat, not the owner of the boat. And these, and especially this type of case, it seems to me that this may end up costing everybody more than what this collateral is worth. Maybe this process works, but then again, the company went out of business. So we're looking at some collateral, and there's really, I know there's a lot of animosity between the parties, but we're looking at a company that had a product that didn't work. We've got a former officer of the company that was stiffed money, and that's why you took the security interest in the collateral. You've got a landlord that is out rent, you know, and the landlord's trying to figure out what to do about it. You've got possible interest in the collateral, but it is what it is. We're not talking about a situation where there's perhaps not that much money at stake. So to the extent the parties want to contemplate mediating this, that might be a good outcome before you spend a lot of time in discovery and fighting over the value of this product. Now, I may be wrong. It may be worth millions of dollars. I don't know. But I'm just saying that this might be a good opportunity for the parties to at least explore an initial round of mediation to see if they can come up with a resolution. I'm not going to order it at this time. When we get to scheduling, I will. Maybe there's more discovery that needs to be undertaken. But like I say, in all my commercial court cases, the cases I were involved in that involved a lot of these similar sort of emotions and fighting. One case I had took 8 years and 2 trips to the Supreme Court. And at the end of the case, neither business partner was talking to each other. They can be very, very long and drawn out. And at the end of the day, you wonder if it was really worth it. So if there's any way to, hire a mediator who has some experience in this area to try to sort through some of this stuff, I would highly recommend it. I know that's, cutting down on your attorney's fees, but I know you're all good attorneys, and I know you're looking out for the best interest of your clients. So, all right, anything else we need to do today?
Judge, is someone going to file an order on these motions?
Yes, who wants to?
I don't mind filing an order, Your Honor. This is Attorney Coley, but I had a clarification question because part of our motion also sought, let me back up. The plaintiff's cause number 6 seeks intentional misrepresentation against the Old World Creamery defendants for what they've defined as the Everson statement. So I just wanted to make sure I understood where you were coming down on that part of our motion in light of the decisions you made regarding the Everson defendants' motion to dismiss.
6 would be out too. Thank you. I should have caught that.
No problem. There was a lot before you, Your Honor. So but back to the original question, I'm happy to prepare an order and I can circulate it before we file it with you if that's okay.
That would be good. And you can just say for the reasons on the record, and again, it's without prejudice. So, all right.
Your Honor, you mentioned scheduling, and there, among the items to schedule are the plaintiff's motion for an in-camera inspection and to compel discovery. And I'm wondering whether it makes sense we've filed a motion and supporting brief in October. And I'm wondering if it makes sense to set a briefing schedule on that motion now.
That makes sense. So how long do the defendants want to respond to that?
Could we have 30 days, Your Honor? Maybe February 15th?
All right. And when does plaintiff want to have to reply to that?
15 days after.
Okay, how about March 5th?
Thank you, Your Honor.
And let's get an oral argument on the calendar right now. How about Diane, how about sometime the 3rd or 4th week of March?
Do Thursday, March 18th at 10 a.m.
That works, Your Honor.
That's okay with OWC defendants, Your Honor.
Okay. I'm hoping by then, how do the parties feel about doing that in person, or do they want to do it by Zoom?
I prefer Zoom, Your Honor.
Okay. All right. I'm not forcing anybody to Frecon over here with everything else that's going on. I don't know people's health issues, so I promise I'll try to have my laptop working by that time. So you can still see me, but my laptop looks dead. So,
Oh, now we can't
Now,
see you.
Your Honor.
okay, yeah, sorry about that. I don't know what's going on, but
So John,
usually I have a bench camera and it works, but the bench camera isn't working and the laptop apparently died. So apologize for that, but I will get it back working by March. I better get it back working by tomorrow.
on the motions or the briefing schedule, do you want me to do one, or can I just put it in the notice of the hearing? You want to, or do you want actual briefing?
You want a separate notice, or is the minutes okay?
I can also put it in the notice for the oral argument.
Yes, why don't you put it in, we'll put it in the notice of the oral argument, so. All right, anything else?
No, thank you, Your Honor.
Did I get all the motions? I guess I did, so. All right, thank you all. Stay
Thanks,
healthy,
Judge.
stay safe, and